Thank you all for coming today. As you know, there is a question on the ballot. It's question 3. It's called the medical use of marijuana question. And like a lot of people, I didn't pay a lot of attention to this during the early process. We're all busy in our lives. We have children, we have parents, we have brothers and sisters, we have schools that we have to take care of. And we're in the middle of a hot Senate race here in Massachusetts and a presidential race. But way down on the ballot is a question. And in it is the issue of the use of marijuana for medical purposes. And I don't think anybody will deny that there are a lot of people in pain and that we have compassion for those people and that we are obligated as a society, as legislators, as people who care about other people to do whatever we can to provide treatment and to help alleviate pain, but to do so in a responsible manner. As I go out and about and I talk to people about this question, they sometimes say, well, medical marijuana, it sounds pretty good. Well, first of all, there is no such thing as medical marijuana, as most people call it. There's marijuana. And there's uses for marijuana, but there's no such thing as medical marijuana. And people say, well, how dangerous could it be? They're going to go to a doctor, they're going to get a prescription, and they're going to go to a pharmacy and get that medical marijuana. That's not true, as I will talk about. And as I go through those types of issues with people, the response that I get is, I can't believe that. But that goes way too far. And ultimately, it comes down to the same response after going through this is, why would anybody support something like that? Well, let me go through a few things. As the doctor said, marijuana under this proposal would be made available for people who are suffering debilitating diseases, and several of them are listed. Cancer, glaucoma, positive status for HIV, AIDS, hepatitis C, ALS, Parkinson's, and MS. There's a real legitimate debate about whether medical marijuana for medical purposes, is proper or does actually help anybody in certain of those circumstances. So it's broad to begin with. But then there's this one clause that's in the proposed legislation. Other conditions is determined in writing by a qualifying patient's physician. Broad, wide open. And in fact, when you look at experience, and I don't know how many people are aware of what's going on out in Colorado, but when you look at the nearly 100,000+ people who have marijuana cards out in California, 94% of them have it for a nondescript diagnosis of pain. Only 1% of those registered are registered for the purpose of HIV or AIDS. Only 3% of those registered are registered for the purpose of cancer. So 94% fall into a very nebulous, broad, vague category of pain. That could happen here in Massachusetts because of the language that says other conditions as determined by a qualifying patient's physician. The other question I get, well, if there's no prescription, how does somebody get marijuana? Well, they get a registration card. Well, that's okay. How long is it good for? A month? 2 months? Until the doctor sees them again? No. The way this law is written, that medical marijuana registration card is good for life. No follow-up checkups is what they have in other states. No follow-up examinations. Here's a card. It's good for life. So where do they get the marijuana is a question that I'm frequently asked. And I say, well, they get them at medical marijuana treatment centers. They say, what do you mean? Is that like a health center? Is that a doctor's office? Is it my primary care physician's office? Is that what they mean by a medical treatment center? No. It's 35 neighborhood stores coming to you. 35 stores across the Commonwealth that will have signage out front, that will have signage in the windows. And if you saw the piece relative to Colorado, you saw somebody standing out in the street with a sign saying, get your product here. This law as proposed does not at all talk about how it is that this will be given to people other than the fact that it's a medical marijuana treatment center. We're going to have 35 storefronts with the appropriate advertising. And so then it comes, well, that's fine. I guess we'll have healthcare professionals working at those treatment centers. Doctors, nurses, pharmacists, other qualified healthcare professionals. No. This statute doesn't provide for any of that. If you want to work at a treatment center under this proposal, you just have to be over the age of 21. That's it. No training, nothing. No medical background, nothing. Over 21 and you're interested, you can go to work in a medical marijuana treatment facility. Well, where will they be located? The statute doesn't say. Schools? Yes, they could be right next to schools. Churches? Yes. Playgrounds? Yes. They are treatment centers where people are trying to recover from the effects of drugs and other substances? Yes, right next door. There is no restriction whatsoever on where these medical marijuana treatment centers, where these storefronts will go. Well, how old do you have to be to go into one of these stores or to get marijuana? Any age? Well, if you're underage, I assume you need the permission of a parent or a guardian. The law doesn't say that. Any age, you're eligible to get medical marijuana. You're eligible to get up to a 60-day supply. The question is, what's a 60-day supply? In California, it's 8 ounces, a half a pound of marijuana. You can walk into a storefront in California, walk out with a half a pound of marijuana. You'd be able to do that perhaps here in Massachusetts. Walk down the street with it in a clear bag, walk by one of these law enforcement officials, and they'll say, what is that? And you'll say, it's my marijuana. And you'll flash your card and off you go. Well, the amazing thing is, you can go home and drop that at your home. You can then get in your car and go back to the center again, or to another center. And you could get yourself another 5 ounces, 8 ounces, whatever it may be of marijuana. You can't possess more than a 60-day supply, whatever that may be. You can't get caught possessing it, but there's nothing preventing you from buying more than a 60-day supply. Other states have tighter regulations, stricter regulations, registration of all this. This law has none of that. Walk in, get what you need, drop it at home, go back and get more than you need. Time and time again, and nobody's going to ask you a question. What about the doctors? What role do they play in all of this? Well, they don't write a prescription. They write a recommendation. It's not a prescription. And the way that the law is written, the doctor doesn't even have to be from Massachusetts. Other states that have passed these have it so that doctors have to be from the state. They have to be licensed in the state where it's being distributed. Not here. Not under this law. Vague, ambiguous, wide open for exploitation. And it doesn't even say in this law that an examination is necessary. Common sense would say that if you are going to make a recommendation of a mind-altering substance to somebody to help alleviate pain, then you should at least be required to conduct an examination. No such requirement under this law. But what about the marijuana that people have? Where do they take it? How is it administered? They can administer it in any way they deem fit. In fact, they can take it in a food form, which this medical marijuana treatment center will be allowed to manufacture and sell. Will it be regulated? Who knows? You're allowed to take it in a pill form. You're allowed to take it in a liquid form. You're allowed to use what they call a marijuana tincture, which is a product that is produced by mixing marijuana with alcohol. And if you look at how you do that, they'll tell you get the highest proof of alcohol possible. Well, marijuana tinctures are permitted under this law. So you will be able to take those products, smoke marijuana, pretty much wherever you want. Well, people say you can't do it in the schools. Well, the law says that there's no accommodation required in schools. It doesn't say it's prohibited. The law says that there's no accommodation required in employment, places of employment. It doesn't say it's prohibited. And it is silent as to whether somebody could stand on these steps across the way, in front of a store, in front of a church, in front of an office building, and smoke medical marijuana. There are no restrictions, no direction in this law relative to that issue. So when I get through talking with people about this, they say, why would we support this? And think of it. Think of the need of people who have legitimate pain. Look at other states, the registration numbers there, it is a relatively small number. And yet, this legislation opens it up enormously. It opens it up to growers, to retailers, to people who have nothing more than some nondescript claim of pain. Common sense and a reading of the actual proposal will tell you this is not about being compassionate to those true legitimate treatment needs. The residents of Massachusetts are being sold a law that goes way beyond the idea of being compassionate. Don't be fooled. Please read the law. Don't just read the summaries. Read the law. There are more targeted, effective ways to provide compassionate care to those truly in need. This is not the way to do it, and I urge that people vote no on question 3. Thank you.